All right, today we're going to dig into a neighborhood dispute that, on the surface, seems pretty simple. It all starts with a complaint about some weeds, but it ends up in a full-blown legal battle. This story is a really fascinating look at what happens when rules are vague, goalposts get moved, and an organization has to answer for the exact words in its own rulebook. And this one sentence, right here, from the judge's final verdict, it gets to the absolute heart of the whole thing. It perfectly frames the central question. Just how specific does an HOA have to be when it tells a homeowner they've broken a rule?
So, where does this all begin? Well, like a lot of these stories, it kicks off with something pretty ordinary. A notice in the mail. A simple letter about the state of someone's yard.
Let's set the scene. The date is January 25th, 2021, and a homeowner named Wesley Chadwick gets his first property inspection letter. The violation? Weeds and dead plants. It seemed like a really straightforward issue, but, as you'll see, it was anything but. And things escalated fast. Just 2 weeks after that first notice, a second one shows up. But this time, it comes with a $50 fine. So Mr. Chadwick takes action right away. The very next day, he pays a landscaper $450 to get rid of the dead cacti and weeds. You'd think, okay, problem solved, right? Well, wrong. 2 weeks later, a third notice arrives, this time with another $100 fine for the same problem he thought he just paid to fix. So after getting that third notice, Mr. Chadwick decides to call the HOA directly, and they work out a deal. He agrees to pay that first $50 fine, and in return, the HOA says they'll waive the $100 one. As far as he was concerned, the matter was settled. He'd done his part, paid a fine, and the issue was resolved. But just when he thought it was all in the rearview mirror, something weird happened. The nature of the violation itself suddenly changed. The goalposts, well, they started to move. Okay, so this is really the core of the whole problem. Check this out. Just 5 days after they made that settlement, Mr. Chadwick gets a fourth notice. Now, this notice was dated before their agreement, but it had a brand new instruction. For the very first time, it didn't just say, please remove weeds. Nope. Now it had this little addition. Fix rock area. The goalposts had officially been moved. And that right there is the million-dollar question, isn't it? Fix rock area. What does that even mean? Legally, what is a homeowner supposed to do with that? Does it mean level the rocks, add more rocks, change the color of the rocks? Without any specifics, how could anyone possibly know if they're following the rule? So even though he's confused, the notices just keep on coming. A fifth, then a sixth, each one tacking on another $100 fine. At this point, the total is over $300, and he has no clear idea what they even want him to do. He felt like this was totally arbitrary, so he did what he had to do. He decided to fight back and filed a formal petition for an administrative hearing. And that brings us to the main event, the administrative hearing. This is where both sides get to lay out their case in front of a judge, and a simple yard issue officially becomes a legal showdown. Mr. Chadwick's case was pretty simple, and it boiled down to two things: clarity and procedure. First, he's like, fix rock area is ridiculously vague, right? But more importantly, he argued that the HOA wasn't even following its own rulebook. Their own documents said that every notice has to list the specific steps to fix a violation. It turns out the real issue was some exposed irrigation lines left behind after the cacti were removed, but that was never ever mentioned in any of the notices. Now, the HOA, of course, saw things completely differently. They argued that their rules give them a lot of leeway to decide what's unsightly. From their point of view, when Mr. Chadwick ripped out those cacti, he actually created a new problem, a hole with exposed irrigation lines, which they just called debris. They basically said he was in a state of continuous violation and that their notices were good enough to get him to fix the whole situation. So the judges heard from both sides. What's the call? Well, in the end, the decision didn't really come down to how the yard looked. It came down to the words the HOA chose to use, or, in this case, the words they didn't use. So the first thing the ruling says is this: the HOA has to pay Mr. Chadwick $500. Now, this wasn't just about him not having to pay the fines. This was actually a penalty against the HOA, covering a part of his legal filing fee. So why? The reason was crystal clear. The judge basically said, your violation notices are a mess. They were vague, they were overbroad, and they were, in her words, nondescript, telling someone to fix rock area,
just doesn't cut it. It doesn't give them a clear path to actually fixing the problem. The HOA totally failed to communicate effectively.
And the whole case really hinged on this one specific rule from the HOA's own playbook, Article 10.9. This was the smoking gun. It says, flat out, that any violation notice has to have a statement of the specific steps needed to fix the problem. The judge looked at phrases like, please remove weeds and fix rock area, and said, nope, that doesn't meet the standard you set for yourselves.
But what's really interesting here is that the homeowner didn't win on everything. Take a look. The judge actually agreed that the HOA wasn't overstepping its authority and that it did give a proper warning. The win was super narrow, but it was on the most important point. They failed to follow their own procedures by not being specific. And that's a huge distinction, right? The HOA had the power to enforce the rule, but they completely messed up how they did it.
You know, this whole thing leaves us with a much bigger question, one that goes way beyond just HOAs. When do rules designed to maintain standards just become arbitrary? What this case really shows is that having a rule is only half of it. How you communicate and enforce that rule is everything. It really points to a powerful idea. If you're going to hold someone to a standard, you owe them a clear, unambiguous path to meeting it. Anything less isn't just confusing, it might not even hold up in court.